All right, hi everyone. Welcome back. If you have been attending our seminar series, or welcome if this is your first one. My name is Angie. I manage the New Ventures BC competition presented by Innovate BC. And Liz on my team is also here kind of managing the chat in the inbox as well. So yeah, today we're talking about managing your intellectual property, and we've got two great speakers here from Fasken, Roger Kuypers and Ling Wong. So I'll be passing it over to them momentarily, but I'll just take you through some housekeeping bits first. So I always like to just give a recap of where we're at here in our series. So we as part of our competition, have an open education series between now all the way through to mid-June. And we're really just at the beginning of it still. So you can see there's still lots of great topics coming up. You're welcome to attend one or all of them. They'll all be recorded. And if you know anyone that would be interested in the education, feel free to share it around. New Ventures BC ourselves, we're a nonprofit. We've been working with startups for the past 20 years. We, of course, are most known for our annual competition that just closed to entries yesterday. So for those who are in the competition this year, we're just going through everything right now for eligibility, and you'll be getting a message from me around next steps by tomorrow. We also have a year-round accelerator mentorship program. We do have a sales accelerator program happening right now and through the rest of the spring. That's for in-revenue companies. And then we also have a whole bunch of online education options, which are free to anyone in BC. And that's all on our website, newventuresbc.com. In terms of community, what else is happening in the ecosystem? We have a fantastic ecosystem of all sorts of organizations here to support the tech community. So here are just a few that I'm aware of coming up. Liz is going to post the links to all of these in the chat in case you want to check any out. I will note the Vancouver Entrepreneurs Forum, VEF. So that's an event New Ventures BC actually partners with VEF to deliver those events. So you'll see us at those events as well. VEF is a sponsor of New Ventures. So for that, we get 4 complimentary tickets to each event that we get to give away. So if you are a founder and are interested in attending the April 26th event, first, please go take a look at the event, see if it's of interest to you. And if it is, feel free to DM me over this webinar, and I'll give you the promo code for a complimentary in-person ticket. I have 4, so once they're all gone, they're all gone. But we'll do it every month. Also, big question we get is, are the slides available? Will this be recorded? So the answer is yes to both. I think Liz is going to link to the page on our website where we post everything. So it's just one post where everything is listed, or you can just look it up on Google. So the slides for today are already posted as a PDF for you as well on that page. And just going to thank my sponsors, and then I'll pass it over to Roger. So our lead partner title sponsor is Innovate BC. Our gold sponsors, EY, Fasken, SFU Beauty School of Business, and UBC Sauder School of Business. Silver, Ace Tech, TELUS Ventures, Output, Vantech, and Volition. And we also have great bronze and media sponsors that are great partners for us. And that's it. So I'm going to stop sharing here so I can pass it over to Roger Kuypers from Fasken, who will start, and then he'll pass it over to Ling Wong, who's also here from Fasken.
Well, good afternoon. Thanks everyone for joining us. I'm just going to switch over to slide mode here, or I should say full screen mode. There we go. So today we're talking about managing intellectual property. And of course, it wouldn't be a legal presentation if I had a big disclaimer, if I didn't have a big disclaimer at the beginning. We kind of know what we're talking about, but there's no guarantees, and you get what you pay for. So there we go. So we are going to focus on the 4 pillars of intellectual property. So that's copyrights, trademarks, trade secrets, and patents. There are other types of intellectual property like integrated circuit topographies and plant breeders' rights and all that. Now the cannabis buzz is over, we don't need to talk about plant breeders' rights, but we're going to focus on the big 4. And what we hope you can take away from this presentation is the three main things are being able to distinguish between these 4 types. I mean, some are obvious, but people are often confused. It's important to be able to look and say, yeah, that's a trademark, this is copyright. And then the next thing we want that we hope you take away from this is a sense of ownership. Not, a general sense of ownership, but knowing who owns trademarks, copyrights, patents, and trade secrets. And that becomes very important because the rules are not, they're not really intuitive, the laws, to a certain extent. It's an area where we find that clients get into trouble from time to time. And it's really easy to avoid problems. And then finally, protection. How do you protect the intellectual property, which is core to managing it? So first of all, what is it that makes intellectual property? What is IP? Well, first of all, there's an intellectual component. The writing of software, books, screenplays, and then if you look at trademarks, brands, logos, products, and then business plans, like for trade secrets, you could have formula, recipes, business processes. And then of course, if you get into patents, you're talking about inventions. Each one of these represents an intellectual effort. It's not a tangible thing. It's knowledge, it's creativity. And so that's what makes it intellectual. And the property part means, well, just because it's something that's intangible doesn't mean you can't own it. It is property, and it is a different type of property. The main thing is that it has commercial value. But typically, if you own intellectual property, it gives the owner a bundle of rights. So for example, the right to sell a product or service, and the right to prevent others from doing so. And we'll explore that a bit further, for example, with patents. And then of course, the right to license others to use your rights. So there's a lot of creativity around commercializing intellectual property. What's your commercialization model? Are you going to make widgets and sell widgets yourself, or are you going to license a bunch of other people to do it? There's a kind of a broad scope of potential use there. So why is IP protection important? Well, first of all, IP is a valuable commercial asset. And for many companies, and particularly technology companies, it's the most valuable asset. And in a moment, I'll show you a slide that demonstrates that. It provides a competitive advantage. So it may be that your intellectual property, if it's a process or if it's an algorithm or something, you have better products, or you even have products that other people can't use. So IP can shield you from competition. LG owns the patents for OLED TVs. Now you may say, well, that doesn't seem right. I was at Best Buy the other day and I saw a Sony OLED TV. Well, guess where they buy the TV from and then rebrand it as a Sony. They add some electronics to it, and so it's a different end product. But really, Samsung doesn't have any, and it's the best. And it's kind of a big deal because it really gives a dominance, that technological advantage, having the very best picture out there in the world of flat panels, and controlling that through patents is a huge commercial advantage. IP protection is also important from the perspective of investors. We often hear, tech companies saying, "Well, I don't know if I'm going to get a patent because we'd never be able to afford, to protect the patent. We know the patent litigation's very expensive." But the reality for technology commercialization, particularly in a place like BC, is I think the best way to think about it is it's a relay race. And so maybe the first few laps are in technology development are on campus. Maybe it's at a UBC or SFU, and then the baton is handed off maybe to your company. And then you're going to run a few laps with that technology. You're going to improve the technology, make it market ready, maybe get a regulatory approval, and then either go to market and then show, get some traction. But then ultimately, most of the local technology companies will then hand off that baton to another company, a big company. That's the exit. We do lots of those around here. And those are the people that are going to be able to enforce those rights. And so so it's not so much a question of, oh, we can't afford it. It's the investors will want to see it. The people who acquire the technology in the company, and perhaps even your customers, will want to know that it's protected because they will be in a position to enforce it. So what makes IP so tricky is that it's quite vulnerable. It's easy to copy, to steal, and to counterfeit. We know with tangible goods, if you are a minivan factory in Oakville, Ontario, and the minivans come out and they go into a big yard and there's a chain fence, and that you've got to break through the fence, and then you have to get the key. We know that with intellectual property, like for instance, software, really easy to rip off, right? I go up to a computer with a memory stick, download things online, and then make thousands of copies of it. And really other types of, like if you look at real estate, you can't copy land, it's finite. Other and more tangible assets, but intellectual property is particularly vulnerable. And so you need to protect it. So let's talk about the value of intellectual property in our economy. And so what this is it's a somewhat updated version of a slide that now goes to, my old one went to 2015, but now we've got 2020. And so there's a consulting company that does Ocean Tomo. They're called Ocean Tomo, and they do a survey every few years of that. What they do is they look at the financial statements for the S&P 500, and they come out with a number that represents what the percentage of the assets on average of those companies that is attributed, that is intangible assets. And so let's look at what they mean by intangible assets, right? So we're talking about patents, brand value, customer data. They haven't included trade secrets, but they would be included too, as software. And of those, for some of the most valuable companies, it's actually the trademarks, it's the brand value that's the most valuable. And we'll get into that in a few moments. And if, on the tangible side, what are tangible assets? Buildings and equipment, cash and bonds, inventory, land, those types of things. So what happened is back in 1975, the S&P 500 average of the companies making up the S&P 500, intangible assets accounted for 17% of the value of those companies. But if you fast forward to 2020, intangible assets represent 90% of the value of those companies. So not buildings and equipment and land or cash and bonds or inventory. It's things like, patent rights, brands, those types of assets that we're talking about today. So intellectual property, so just to give you an idea about the interrelationship of the different types of intellectual property within a given product, I've got kind of a question: what types of IP protect software? Now, if we were in a room and I would, have everybody put up their hands and, suggest, but I'm just going to go ahead and say it because the online format's a bit awkward for this kind of crowd work, as you could call it. So the IP that protects software, well, first and foremost, IP is protected by copyright. So all the code that you have in software is considered a work under the Copyright Act and is protected by copyright laws. Now, if you look at the example, quite a boring one, I know, that I have on the screen here, Office 365. Office 365 is a trademark. And so Office, particularly Office part of the trademark, that's also a different type of intellectual property that protects that product. So let's say someone ripped off the software and put out something that competed with Office 365. They wouldn't be able to call it Office unless it was a counterfeit good. They wouldn't be able to call it that. And so that's a big deal. A lot of people may go to a store and they'll look at the shelf, or, who goes to a store anymore? Who am I kidding? I'm showing my age here. So they're online and they're surfing for apps. And then they've got two apps on a screen and they get to pick one, and they can go, well, I've got this one and I've got Office. Well, I know Office and it's Microsoft, so I'm going to get that one just because you know that it's probably going to work. So that's the trademark component. We also know Microsoft has one of the largest patent portfolios in the world. So there are aspects of Office, things that you see and don't see, functionality, algorithms, and other things that are protected by patent. And so other people could try to set about creating Office, but they would have to be careful that they didn't infringe the patents. And then finally, the fourth type of intellectual property we're talking about today, which is trade secrets, is also part of the intellectual property that protects software. So most of us were familiar with the difference between object code and source code. And so source code for Office is a trade secret. You don't get to see it. It's not what is downloaded onto your computer. You end up with the binary code machine language that goes onto your computer that's processed. But if you wanted to really see how Office functions, if you got a source code copy of that, that would give you a great insight into how all those programs work and how they work together. But you don't get to see that. It remains a trade secret. So when you look at your products and services and you're thinking about intellectual property management, don't just think about, okay, we're going to do this thing. Oh, it's protected by that. Think about, maybe think about IP being like a quiver of different arrows, and you're better off with 3 than you are 1. So we're going to start with copyright. So I'm going to talk about copyright and trademarks, and then Ling's going to talk about trade secrets and patents. So simply stated, copyright is the sole right to produce or reproduce a work or a substantial part of that work. And I'll give you some examples of what works are. That's the word that's used in the Copyright Act. But the really important thing to get is that copyrights protect the expression of an idea, not the ideas themselves. So if I have the idea for a country music song where a guy's truck breaks down, his dog runs away and his wife leaves him, that's just an idea and there's no protection for that. And if I was stupid enough to actually write a song about it, though, with lyrics and with music and finish that, that would be protected by copyright, not the idea. And it's an important distinction because we sometimes get letters, our clients get nasty letters from people and they say, you're infringing our copyright because your product does this, this, and this. It's like, well, no, it's fine for the product to do this, this, and this. Copyright protects what does it look like? What's the text that's used? What's the software? Specifically, how are those ideas expressed? So works, here are a few examples. The first, sheet music, and the second and third, and I tell you, that's an old Expedia screen capture, very old. And I went to refresh that when I was refreshing this presentation. I went online to first I went to Expedia. And the new thing about, like the style of website presentations changes all the time, right? So you got to keep up with the times. The current style is to have websites that are incredibly spare and uncluttered. So for the purposes of this presentation, that's kind of useless because the point I'm trying to make is how different copyrights can coexist in one large work. And so that's why I've got the old Expedia web capture. I'm not lazy. It's just the new ones just don't do it for educational purposes. So,
hey, Roger, there's a question in the chat. Do you want to wait till?
Yeah, sure.
Yep. Okay, so it's from Sean, who says, I run an indie video game micro studio, filed a copyright for their game title, but later found out someone else had filed a trademark using their title's name. Where does that leave them, generally speaking?
Okay, well, copyright and trademarks are 2 different things. Is it that we're talking about that you filed a trademark for your game title and someone filed a trademark later or before? Because we're going to go, when we go through copyright, we'll talk about what that is. And the reality is, and I'll get to it, is that most people don't register copyright because the rights that you get are automatic, the rights that you get automatically under the Copyright Act are almost as good as what you get through registration. Trademark is totally different. And so maybe what we should do is we'll go through copyright, and then we can talk about trademarks, and then maybe afterwards we can revisit this, and we'll do that with the benefit of having kind of identified the 2 main types of IP that are relevant.
Yep, sounds good.
Is that okay?
Yep.
All right. So going back to the second 2 examples, what you'll see there is that the Business in Vancouver cover and the antiquated screen capture from the Expedia homepage are in and of themselves, each one of them are a work, right? Something that is protected, but they're made up of a whole bunch of different works. So if you look at the business in Vancouver, you'll have a photograph there. A photograph in and of itself is a work. Then you'll have a text. So an article is also a work. And what this represents is that the cover is one work comprised of a bunch of different works. And that's actually quite common. Most, products and or things that are protected by copyright are composite in that way. So what are the requirements of copyright? How do you get copyright? Because as I said, copyright arises automatically at law, and you don't have to register, and there aren't great benefits to registration. But there are two things you need, and one is referred to as originality. And so what that means is that it needs to be more than a copy of another work, but it needs to reflect the exercise of skill and just judgment, but not necessarily creativity. And so the decision in Canadian law that established that is called the Teledirect decision. And it was based on what you can see there in the bottom left-hand corner of the screen, which some of you may recognize as the white pages. So before the internet, what you would get is you'd get a very large book that lists last names and names, addresses, and phone numbers. And so what someone had done was they had reproduced the white pages, and the people that reproduced the white pages were taken to court by the people who prepared the white pages. And the court decided that merely taking names and other information and just listing them alphabetically wasn't enough. It just didn't require the skill and judgment that met the requirement of copyright, but pretty well everything else does, and certainly Starry Night does. The second requirement of copyright is fixation. It needs to be expressed in some material form. And a good example of that is that if you were to go to the Vancouver Playhouse and see a play, what you see as it unfolds is not protected by copyright. The script may be, but actually what you are seeing, the actors, the movements, everything that occurs before you is not protected by copyright. But if someone were to take a video of that, the video would be what you've seen in fixed form. It would be in a material form, and that's protected by copyright. So you'll see sometimes at the end of a hockey game, when they go towards the end and the credits, they'll say, copyright XXX, like much like a play. A hockey game in and of itself isn't protected by copyright, but if you have a fixed version of it, which would be a recording, that would count. So I'm going to talk about something that's pretty well specific to Canada, and it's kind of weird, and most people miss it, but it can cause problems. And it's referred to as moral rights. And so moral rights under the Copyright Act go to the author. So if you are the author of a work, if you code software, if you create a sculpture or a photograph, if you write a book, you're the author. And you have, in addition to the rights that I mentioned right off the bat, which is the right to reproduce that work, you also have moral rights, and moral rights include a few things. One is to be attributed with the work or remain anonymous. So if you're the author of the work, you can insist when people reproduce that work that your name's going to be on it, or that you remain anonymous. That's not such a big deal. But there are two others that are a big deal. One is that you can object to someone modifying that work. And so if you create the work and you're the author, you can prevent anyone from making changes to that, because changing it is an infringement of your moral rights. The third one has to do with use. Let's say you're a painter, you come up with a beautiful painting and you sell it to someone, and that person owns the painting. But if the person who owns the painting then allowed someone from a political party to take a picture of it and use it for a background at political rallies, that is a use that you could object to, that because the work is being used in a way that you hadn't intended it to be used, and perhaps in a way that you really don't approve of. So it's fine. So you can buy a painting from an artist, and the expectation is that it would be hanging on your wall in your home or your office and people would view it. And that in and of itself wouldn't be an infringement of moral rights. But the example of using it for a different purpose would be. So the example I have of a moral rights infringement, and it's a little blurry, and what you see to the right part of the screen is the atrium in Eaton Center. And what you can see at the top of the Eaton Center is it's not actually birds flying through and making a mess of the shoppers. And it's a mobile sculpture of Canada geese. And so what happened one year was there used to be this department store called Eaton's. See, that's how old this presentation is. Department stores don't even exist anymore. Age creeps up on you. So what happened was one year the folks at Eaton's thought, it would be a great idea. It's Christmas. Let's get in that Christmas spirit. We're going to put Christmas decorations on these Canada geese that are flying through the atrium. And so what happened was the artist who created that mobile sculpture said, that's an infringement of my moral rights. And then Eaton's kind of said, what's that? And they didn't do anything about it. So he went to court and he got an order and they had to remove the decorations. And so, I mean, that all seems kind of esoteric and nice to know. Let's put it in a different context. Let's say that you hired someone to code your app, and you paid them and they assigned ownership to you, but they didn't waive moral rights. 2 years go by and you want to do some bug fixes and you want to update the app. So you're going to hire another coder to go into the source code, change the app. Well, that is an infringement of the moral rights of the first, the owner of the software. And so that's something to be mindful of. But there's a real easy fix for that. And for example, in employment agreements, you just put in, it's like a one sentence that you can put in employment agreements, or in a different form, you could put it into like a contractor agreement, which says the employee shall and does hereby waive all of his or her moral rights in the work product. So moral rights only owned by the author, and they can't be assigned. So sometimes you see agreements and then a corporation is like, I'm assigning the moral rights. It's like, no, only humans can own moral rights. So this is the one sentence that you put in your employment agreement to make sure that your disgruntled employee doesn't come back and say you can never update your software.
Oh, hey, Roger, just a quick clarification.
Yeah.
Nancy, you can waive moral rights. Nancy was asking if they can be sold or it can only be waived.
You can pay someone to waive them,
okay.
Right? So that's kind of like selling the waiver of your moral rights. When you hire people to, like, it's one thing that when you have, let's just take a step back. If you think about the concept of moral rights, if you go back to the beginnings of copyright legislation, back into the 1800s, at that time, there wasn't any software. And so what copyright sought to protect wasn't so much kind of utilitarian industrial, it was more art. And so you could understand that the concept of moral rights would kind of flow from that, that if you created a painting or sculpture, that you wouldn't give people the right to wreck your art, because it's an integrity issue. But you can see though now that if we as copyright has attached to a much broader spectrum of things, and many of those things have more of a commercial purpose than an artistic purpose, moral rights doesn't fit so squarely within that context.
Great. And then, sorry, one more question from Mustafa. So if they have someone that creates any type of content for them, is that good enough to bring moral rights terms to their terms of use for their product?
The person who creates the content should be waiving their moral rights.
Okay.
And it should just be in the contract. Now, if the contract isn't with your employee or with an individual contractor, then typically we would have a provision, like if it's with a company, You would just have the company agree to ensure that all of the persons involved in the creation of the deliverables waive his or her moral rights. It's one sentence and it addresses this. It's kind of esoteric, but it's kind of a big one potentially. So we'll move on from moral rights. Let's talk about ownership of copyright, because one of the things that I said at the beginning of the presentation is we want you to get a sense of who owns intellectual property, because that's, it's important for a company to own their intellectual property. The investors want that. The people who buy the company down the road want that. So it's important to get that right. So as a general rule, the author, or if you want to consider it, the creator of a work, is the first owner of copyright. Now, the exception to that is that if someone is an employee of your company and they create works in the course of their employment, so if you have an employee who's a coder, then it's actually the company that owns the copyright right off the bat. And so that's a good bit of protection for employers. But where it becomes risky and where we often find that our clients get into trouble is where they use contractors, because contractors are, commonly used, and there are really good reasons for using contractors. But you don't have then the employment, the automatic assignment of ownership part of the Copyright Act doesn't apply. So if you're using a contractor or freelancer or whatever, you'll need to have something in the contract that says, usually it says, on full payment, the contractor will assign all rights, title, and interest in and to the deliverables to the company or to the customer, right? That's it. It's one sentence. And what happens is we do these due diligence exercises. A couple of weeks ago, it was actually more like a month ago, I was working on 2 due diligence exercises. One was a deal, it was 220 million. One was 240 million. Both situations, the trademarks had been screwed up. In one situation, and just kind of bad contract, not protecting rights, existence of prior rights, like could have just Google searched, and we'll get into that later, to discover that other companies actually were using these marks. The one for 220 is gone. Pencils down, tools down, deal over. A couple of founders probably were already thinking about what they were going to do with $110 million each, after paying the taxes. Imagine going through the rest of your life. Like, that's not a big fish that got away, right? That's a tough one to swallow. And the second one, the one that was 240, it was down tools, the deal's back on, but they knocked $50 million off the price. And these are both situations where, startup companies, little mistakes with big consequences. So let's just do a kind of practical copyright ownership case study. And so what we're going to do is, let's say that you came up with the idea. We know there's Easy Park, when you go to a parking lot, or if you park on the street, there's pay by phone. And maybe you've used those parking apps and you thought to myself or yourself, I think I could do better. I don't think these apps are good. I'm going to make a better app. And so if you think about in the creation of that new parking app that's going to compete with Easy Park and pay by phone, you have a number of people who participated in that product, people that are critical to the product development. So you have the person that came up with the idea. I'm going to do this parking app, but I'm going to, here's a couple things I'm going to do, make it better, right? That's the person who came up with the idea. And you have the person who paid. So maybe it's the company. So you start the company to make this app, and then it is the person who paid for the app, paid everybody that was working on the app. And then you have the software architect. So what does the software architect do? Well, software architect says, okay, we're going to make a better parking app. Here are how the modules are going to look, right? User login, ID piece, payment processing piece. A lot of that's just going to be licensed in. Some of it will be open source. And then we're going to have the special sauce code, maybe some algorithms, something else that has the functionality. And then you sketch out like on a tablet or something, and this is where they're going to interconnect. And then you go to a coder and you say, oh, hey, so we came up with this great idea. We're going to improve. We're going to be better than Easy Park Pay by Phone. We got some money from someone who's invested, and here's how it should look. Okay. This module should go here, and then this module and all that. And then finally, at the end of the day, you go to the coder, and the coder, uses the skill, understands the language, figures it out, codes it. So the question that I'm going to ask you, and there's no need to respond because it's kind of awkward in this format, is who among those parties, the idea person, the money person, the software architect, or the coder, at the end of the day, that app, that piece of code, who owns copyright in it? Coder. Coder owns the copyright. We know probably thought, yeah, probably not the person who paid, for sure the architect, right? And probably the guy who thought of it or the gal who thought of it, right? No, none of those people. The coder. Copyright is the expression of an idea. Who expressed the idea at the end of the day? There's the coder. So where does this become important? If that coder is not your employee, you don't own your app. What the law will say, what the courts will say, is that if you hire someone to code that app, you'll have an implied license to use it, but you won't own it. And when you're big, when someone comes along and they want to pay $220 million for your app and they want to do an exit, they're going to make you go back to the coder because you're going to have to convince the coder to sign something to assign that copyright to you or your company. So anyways, these are complicated concepts with very easy fixes, but we see this come up a lot, and it's important to know.
A couple follow-on questions for this, Roger. So you may have answered this, but first, Cheryl's wondering, does a company automatically have copyright of their software, or do we need to file for copyright? Or I guess maybe the coder has it. Filing
for copyright isn't terribly relevant. You could file for copyright on something you own, wouldn't make you own it. As I mentioned, it's not very common for people to file for copyright. That's not how you get rights. I mean, certainly, yeah, it is a way of getting a level of rights that's better than the rights you get automatically. But if you want copyright, remember, you need to do two things. There's two requirements, right? Your work has to represent the exercise of skill and judgment, right? Almost everything that people create entails that. And we know that the putting names in alphabetical order doesn't. But apart from that, you're probably met that requirement. And the second requirement is that you have put that work in a tangible form. So it's not the idea for the crappy country song, it's the actual song, the actual lyrics and the actual music. It's not the idea for the book or the movie, it's the book or the movie, it's the screenplay, it's the tangible part. Those two things and you have copyright.
Okay, cool. Josie and Saeed both got your case study question right before you answered it, so way to go. Another point of clarification from Sean and Nancy. Sean's asking about how this applies to freelancers, and kind of related to that, Nancy's, I guess, confirming that unless the coder is the contracted person to write the code and waived it for stock options, then the company would have the copyright. Is that fair?
No, because you need words of assignment. So you may pay the coder in shares, and that's fine. But as I mentioned, you can pay the coder and still not own the copyright. All the law would say is that you have an implied right to use it, but you wouldn't own it. And so it's just important to say, you could do it on one page or half a page. If I grant you these options, you will assign all of your right, title, and interest in and to the software to the company. Boom, one sentence. And when we're doing our due diligence and we're going through all these, it's all on data sites. It's what you're looking for. Every contract. It's like, okay, where's the IP part? Where's the IP part? Magic words. Okay, next one. And then what we do is we end up with, that's what I've got to do after this presentation is I've got to go through a disclosure schedule. And the main pain in the butt that we're not talking about today is open source code, but someone else can talk about that at some point. But that's actually what we do. We go through and we say, no, these are all fine. Looked at the standard employment. Oh, this is your standard employment agreement. It's fine. And then you get one step closer to the check, right? But if you don't have those things, then you either need to address them. You can get, they could grind you on price, or they could walk away. So, concepts are complicated, but the solutions are very simple. It's important. And you guys are just getting started for the most part, so you can get all this stuff right. Yes. You can send me a postcard when you're rich and famous.
Nice. And then this is a good segue, because I don't think you've addressed the slide we have in front of us now, but Eve had a question about this. If copyright arises automatically, what's the point of using the C notice?
Oh, well, the C notice is a way to put people on notice that you have copyright. The reason would be this: if someone infringes your copyright and they often go, oh, well, it was on your internet, so I just assumed I could use it, or that, but C, it indicates like, or I didn't know who owned it, and I couldn't figure out who owned it. So you put the C in a circle, and then you put the name of the owner and typically the year of publication or the year that the work was finished. And then you often see the statement, all rights reserved, right? And that's pretty good, because what that does is, even though people don't get to rip off your copyright anyways, when you go into court, it makes the proceedings a lot shorter, because they can go, well, I didn't know there was copyright. And then you could say, well, there's a circle C. Well, I didn't know who owned it, so I didn't know where I could get permission from. It's like, well, the owner's right there. Oh yeah, but I thought because they put it on the internet that I could do whatever I wanted with it. It says all rights reserved, right? So that makes that part of the proceeding much shorter. But
and is that across?
Sorry,
I was going to say, is that across all regions or just Canada?
It's pretty well across most of the world, because copyright law. So there are differences. Like, for example, moral rights don't exist in most countries. There's a variant of moral rights that I think exists maybe in England and Australia. They certainly don't exist in the US. So that's different. But most countries going back to the late 1800s have kind of a reciprocal recognition of each other's residents' copyright. So you don't have to go and spend money and, it's all like, oh, I didn't register my copyright in Spain. It's like, well, you don't have to worry about that, because that's already part of the international copyright regime.
Okay.
So it's great for people and bad for lawyers. So, so by all means, do use the C in the circle. You don't have to use it everywhere that your work appears, because that can be pretty unaesthetic, given how important it is in today's world of graphic design to have very spare, open presentations of things. Registration of copyright is something you can do. It's simple and inexpensive to register. Usually we don't, and the main benefit, see the copyright legislation in the US and Canada, and I think a number of other places, they've got what's referred to as statutory damages. So it'll say in the US Lanham Act or whatever, for each copy of something, you owe so many dollars or so many cents. And then it gets interesting in a hurry, because if someone rips off your software and then sells 100,000 copies of it, you can instantly say, well, send me $200,000, because that's what the act says. You don't need to even register for statutory damages anymore in Canada and the US. It used to be that one of those jurisdictions you had to. The main benefit of registering copyright, and when you do, you don't even send a copy of the work. Like, all you do is you put in the date of publication and the authors, and then you give the work a name, and then the owner, and you send in your check for $250, or of course you'd like to do the online payment for $250 dollars, and they don't even want it, because they would just have warehouses full of like books and stuff. And it would be a fire hazard. So that part of it's simple. But I think the main advantage of registration would be that if you were to go into court and you were suing someone, you can say, here's the registration for the copyright. And then that little piece of paper you get from the government would be like prima facie evidence of your copyright. but most, very, very few of our clients bother registering copyright. So copyright management, obviously focus on ownership and rights, how works are developed. Think about how works are developed and in order to determine who owns it and what the rights are. And then look at the contracts, you know, with your website developer, your coders, and try to include the magic sentence. Wow, I put it all in one sentence here. So, you know, contractor shall and does hereby assign to customer all rights, title, and interest in and to the deliverables, and shall ensure that each author of the deliverables waives all of his or her moral rights in and to the deliverables. There you go. Put that in the agreement and then forget about it. So I'm going to have to speed up. I thought I was going to end up going much quicker, but got stuck in the woods a little bit. I will blaze through trademarks and we'll have time for questions later. So trademarks, my favorite type of IP, are used to indicate the origin of goods and services. When you see the mark, you understand where the goods or services come from. So trademarks can be words, designs, the shape of goods, like the Coca-Cola bottle, the shape of their packaging, or a combination of colors. So MasterCard owns the combination of red and yellow in connection with credit card services, and also sounds and scents. And there are a few other more esoteric things that are considered trademarks. So why are trademarks important? Well, the goodwill associated with the products and the companies reside in their respective trademarks. Consumers make decisions based on trademarks. I want a Toyota and not a Kia. I want a Rolex and not a Seiko. So what happens is the trademark is this thing that customers carry around in their head that tells them what to buy when they have choice in particular services or goods. And that's very valuable. So Interbrand is a company that does every year, every couple of years, it does a survey of global brand value. And so in 2020, the value of the top was Apple, unsurprisingly, and they thought that brand had a value of 322 billion. And you can see that the top 10 list is populated. What we've seen over time is that the old school, more industrial type companies like automobile makers have gone down and the internet companies have come up. But so why is, so you may say, well, why is Apple worth $322 billion? Well, when Apple comes out with a new product and they put the Apple logo on it, people will camp out around the corner for 2 or 3 days waiting for this new product because it's Apple. And Apple's like, people refer to trademarks as promises. And so the Apple promise right now, its brand is that this is going to be something really different, and it's going to be really convenient and creative. And so there's incredible value in that brand. So requirements. What are the requirements for a trademark to exist? Well, first of all, it needs to be distinctive. It needs to be able to distinguish your goods and services from those of your competitors. And I'm going to get into that in a moment. But after that, and especially over time, like you can apply to register a trademark, but at the end of the day, what you really need is you need to use a trademark in commerce in order to continue to have rights to it and to have rights to it. And so use of a trademark goods is like if you put them on the goods themselves, like the pill, or on the packaging. And with services, because services are they're intangible, it's harder to stamp them with a trademark. It would be in the advertising for those services. Advertising becomes important there. Or if it's on the invoice, when you give an invoice for your services, those types of things. So the ownership of trademarks is unlike, you'll find that when Ling talks about patents and trade secrets, that they're kind of like copyright. They're really, really connected to the people who created, invented, created, authored, all that. Trademarks are different. Trademarks are owned not by the person who thought of it. They're owned by the first person who either uses the trademark in commerce or registers the trademark. And part of that is just filing an application, because that puts you in line for the registration of that mark. So trademarks management, what does that entail? Well, first of all, the most important thing is pick good trademarks. And then once you pick the trademark, register it, and then finally enforce it. But let's talk about the important things. So you want to pick a good trademark for your product or your company. It needs to be distinctive. That's the most important thing. And there are two aspects to distinctiveness. It shouldn't describe your goods and services. It shouldn't describe them, right? And it shouldn't be confusingly similar to your competitors' trademarks. Bit of a no-brainer, but people are often tempted to, if they're doing software, 20 years ago, it was like, oh, I'm going to call it something soft, Macrosoft. Yeah, I'm going to call it Macrosoft. It's like, yeah, because you want it to sound like Microsoft, because Microsoft, has a kind of a brand presence in the marketplace, but you're going to get sued by Microsoft if you do that, because it's too close, it's confusingly similar. So let's talk about the first taboo, descriptiveness. So a trademark, and I'll give you an example, Volvo. Volvo is known for safe cars, but it can't register a trademark safe cars, because if it did, then it would prevent other car manufacturers, Mercedes, Toyota, whatever, from saying that their cars are safe, or using the word safe and close to cars. So there's an anti-competitive aspect to it. And the best trademarks in the world are ones like Google. Like, what on earth does that mean, right? Or Apple in connection with computers, like just completely distinct from what they are. Confusion, obviously, so the second thing, make sure that your proposed mark isn't confusing with others in the marketplace. But one thing to bear in mind, when you're considering the issue of confusion, the trademark rights are limited to how you use the mark. So we've got Delta, Delta, Delta. We've got airlines, hotels, and faucets. There's no confusion across those brands because they're really in distinct areas of use. So that's fine. I mean, nobody's going to go out to buy a faucet and end up in a hotel room. That's not going to happen. So it's important to think about when you come up with a good trademark and you're doing searching to see if somebody else has, you don't go, oh, there's already an airline called Delta. So that's fine if you're not in the airline business. Another consideration if you're looking at foreign markets, and that is connotation. So we talked about descriptiveness and distinctiveness, and then within the Canadian context, and the US and other English language countries, that's fine. But if you're looking at products and services that are going to go into countries that have other languages and script, you need to consider the connotation of your mark in those markets. So for example, in 1997, Nike came out with shoes that had the Air Flame logo on the back. But what they didn't realize at the time is that it looked like the Arabic script for Allah, and they put it on shoes. That was not well received. Not at all learning from their mistake. They did something similar 22 years later in 2019, the Air Max 270 logo, and they had a script that was similar to Allah, but they put it on the sole of the shoe, even worse. But that's not really the most notorious example. The most notorious example is Chevy Nova. There used to be a car called the Chevy Nova. I think it was probably the first car that I owned. And they sold the Chevy Nova in Mexico, but the problem is that Nova in Spanish means no go. So it's kind of like the car that doesn't go. Kind of dumb. You would have thought that someone at General Motors, tens of thousands of employees would have said, oh, excuse me. Nova means it doesn't go. But no, they went to market. Big mistake. So for trademarks, I'll go quickly here. What you need to do before you adopt them is to search, right? You can figure out whether or not something's descriptive, but if you want to find out if someone else is using it, you can search. And there are two types of searches. You can go and you can look for statutory rights, because remember, you can have trademark rights if you register a mark, but also if you use it. So you can look for the registrations and applications by going online, and I'll show you those screens in a minute. But then also you can do common law searching. So the common law are the rights that you get just by using a trademark in commerce. And Google's your best friend there. Like, you can try to do some investigations to see if people are using them. And so the main trademark search tools are, you've got knockout searches. You can order full availability searches. There are things you can, call up a lawyer, trademark lawyer, and say, I want to do some searching. And then you can also do investigations. If you find that someone in Flin Flon, Manitoba apparently is using the trademark in the same area that you want to use it in, you can investigate, see if they're still doing it. Because remember, trademark rights are dependent on use. So if someone's abandoned a trademark and hasn't used it for 5 years, their rights should be extinguished. So this is what the online search looks like at the CIPO site, CIPO, Canadian Intellectual Property Office. And this is the one at the USPTO site. So you can kind of get started when you've got your list of potential trademarks and search those sites to see if there are some applications or registrations already. And then if you pass that test, then you can go on and do some more searching or order searches, and we can help with that. Registration is by country, except in the EU, where you get 27 member states for the price of one. Cost in Canada is about $2,000 from beginning to end, with including legal fees and the filing fees, for one class. It's more if you do more classes, but it could be more expensive if an examiner finds out that your mark is like another mark in the same area of commerce. You'll get an objection. You have to deal with that. And also, third parties can oppose your applications. In order to get to registration, an application is published. And if anybody has nothing better to do than to go through the Trademarks Journal, and they find this and they go, oh my God, someone's trying to register a mark that's just like our mark, and they're in our field of business, they can oppose. Enforcement, CIPO doesn't do that for you. Keep an eye on the marketplace. One of the things that keeps us the busiest here in our group is sending cease and desist letters, which we also call crapograms, on behalf of our clients to other people where they've used marks or sometimes infringed copyrights, and we send them a legal letter, and it usually gets them to stop. So I've gone on far too long. I know it says trademark questions. I think we should probably transition to Ling, and then we'll have some time for questions afterwards. Sorry, Ling, went way longer than I thought.
No
Yeah,
worries.
there are a few questions in the chat, Roger, if you're up for just responding in the chat. Otherwise,
Sure.
We'll follow up after.
Okay.
Over to you, Ling. Thank you, Roger.
So I'm going to quickly talk about trade secrets and then follow up with a short discussion on patents. So first of all, what is a trade secret? There are certain requirements that that you have to meet in order to have a trade secret. First is that it has to relate to information that's not generally known. And secondly, by virtue of it not being generally known, it has to have a commercial value. And thirdly, probably the most important factor, you must have taken reasonable efforts, or reasonable efforts must have been taken to maintain that secrecy. And as I talk about trade secrets, I'm sort of folding into that what we sometimes refer to as confidential information as well. I mean, technically speaking, trade secrets is a subset of confidential information, but for today's purposes, I'm going to essentially treat them as the same. So some examples of trade secrets. So this can be, something like like formulas, or maybe a manufacturing process, some sort of know-how, but it also encompasses other things as well. Things like marketing plans. Maybe you have confidential sort of development plans that you have, or even customer lists. So there's a fairly large category of things that this can encompass. And also, as we'll discuss later, this can also include inventions. So you come up with an invention for initial purposes, you should still treat that as a trade secret, because there are implications of letting that information out. So the advantages of trade secrets. The first and then probably the most important is that trade secrets never really expire. Unlike something like a patent or an industrial design right, those require you to file an application and obtain a registration, but it has a definite life. And so that means the extent of protection is somewhat limited. For trade secrets, that there is no term as such. As long as you preserve that secrecy, then it can last indefinitely. And the other requirement, the other point, of course, is that you don't need to do anything really to obtain that protection. You don't have to file anything with the government. You don't have to actually register it. And so, it can be very powerful in that respect. And as I identified there, trade secrets can be very successful. And we've got some examples there of some recipes and formulas that are still preserved today and doing very well. Now, I think of trade secrets really as a do-it-yourself form of protection, because it really relies on you, as I mentioned earlier, to take those reasonable steps to keep that secret. There are some disadvantages, unfortunately, with trade secrets. So the moment that information is let out, and then it's gone. So in the case of someone puts your formula for WD-40 on the internet or otherwise discloses it, then you can't put the cat back in the bag. It's gone, and it's no longer will qualify as a trade secret. Another problem potentially with trade secrets is that you can't actually prevent someone from creating the same thing or independently creating your process or your secret source, because there's no actual protection for what the information you have. They can independently create it, and it's also a risk sometimes in that they may reverse engineer your solution, and maybe in some respects, if they have something which is patentable, they could even take the next step of actually securing patent protection for that innovation. And then you will lead to the sort of somewhat perverse result where something that perhaps you created first, but you didn't take steps to protect it, but you maintained it as a trade secret. Maybe someone else comes along with the same solution and they get a patent for it, and then they end up enforcing that patent against you. So that it can be something that has to come into the equation when you're figuring out whether the risks are worth it or not. And then there's a practical aspect of trade secrets in some situations. You may have, your trade secret may relate to something which, once you've sold it to the public, they can kind of take it apart and they'll actually be able to see how it works and or reverse engineer it. And so in that situation, trade secrets don't really apply because it's, once you've sold the product, or maybe it requires you to share that information when you are dealing with manufacturer to make that product, they easily will see what that secret source is. And so we're just going to touch very quickly on ownership. Much like as Roger mentioned, we want to be able to make sure that we secure the ownership, or the ownership resides in the right party's name. So we think of the situation of an employee who's come up with a technological solution, and or maybe that's an external contractor that's been working on that solution. They come up with something which potentially is valuable. Who owns that? And the sort of short take home here is really make sure that you have contracts in place, much like for copyrights and to some extent with patents. If you have the right contractual terms that first of all assign the rights to the company, then that takes care of, I would say, 80% of the potential problems. On top of that, of course, you also want to make sure that there are related provisions dealing with confidential information. So you want the people who came up with that trade secret or that have access to it to maintain the secrecy, because maybe it may well be that you own the rights to this trade secret, but if they turn around and share it with the world, then that's not worth very much. And so you have to make sure that those sorts of provisions are in those contracts, whether it's an employment contract, whether it's a contractor agreement, consulting agreement, or some other side, side agreement. So I mentioned earlier that you have to take reasonable efforts to maintain the secrecy of that information. What that looks can vary from case to case, but you do have to show that you've taken what will be considered steps to, for example, restrict access to that information, and that you've essentially warned the people who have access to it that that's really on a need-to-know basis. And so as a result of this, it's quite important. So even though I thought I described this as a DIY, do-it-yourself type of protection, you still have to take fairly extensive steps to maintain that secrecy. And a trade secret management program is very helpful in that respect. So what does that involve? So first of all, typically, you want to make sure that you can identify the trade secrets themselves. If you don't identify the trade secret, it's very hard to kind of take steps to protect it and to maintain secrecy. And then with respect to the actual policies, depending on the form that trade secret information exists as, if it's in document form, you might want to make sure that you mark it appropriately and you say, hey, this is confidential information. Make sure you don't share this with anyone outside the company. This information is on a need-to-know basis only. Things like that to at least warn the person who has access to that information. And then particularly with respect to sort of computers, you want to also restrict access in an electronic form. So things like passwords, access controls, again, pop-ups that come up that warn the reader that you're potentially accessing company secret information, restricting things like drives and USBs so that the sensitive information isn't quickly downloaded. All these sorts of things are sort of part of the process, and a lot of them are sort of fairly common sense, but it is still very important that you sort of go through the process and think about, okay, what steps should I be putting in place to demonstrate that I've taken those reasonable steps. And so these are some of the examples of external threats. So I mentioned previously reverse engineering, or maybe some kind of active attacks in terms of maybe an outside party hacking into your server to try and get access to the trade secret information. Typically these are kind of external threats, but the reality is that most trade secrets are at risk really from kind of internal sources. And so usually this is kind of employees that inadvertently share the information, or in some cases, maybe that they're actively engaged in doing that. And so this is, again, something that company executives and people in charge of this information, this is the sort of thing that they should turn their minds to. And so, what is the sort of the benefit of all this? Well, if you have a trade secret and you've taken all those reasonable steps to make it look like a trade secret, the effect is that if someone tries to steal that information, you can actually enforce that against them. You can try to stop them from taking that information and kind of like selling it to a competitor, whatever it may be. So you can actually take steps to stop them. However, it is fairly limited because, as I said, if you think of the situation where maybe you have a disgruntled employee and all he wants to do is to cause havoc with your company, he puts it on the internet, and so in that situation, the fact that it was a trade secret, we can't really enforce it in that way because the information has already escaped. You can sue them for damages, but the trade secret itself is it's lost. So that's it for trade secrets. Were there specific questions, Angie?
I was thinking maybe we'll just let you go through patents.
Yeah, maybe I will.
We'll do the questions after just to make sure it's covered.
Absolutely.
Thank you.
Okay, so on to patents. And so, where this usually arises is where you've got a company that's developed an innovation that perhaps makes your products or your services better, cheaper, faster. And the goal really in this situation is to kind of retain some sort of exclusivity to that. And you want to prevent your competitors from kind of copying or using that technology. And this more properly applies where you've got something which, for example, doesn't qualify as a trade secret. And so you gotta, well, what else can we do? Because once you've publicly disclosed it, then anyone else can in theory make use of it. So so in terms of why go through the patent process, a patent actually gives you the right to exclude others from making, using, or selling the claimed invention that you've come up with. And so that's the sort of the protection that you get. You basically get to tell them to back away from a certain area, and then you maintain a period of exclusivity for that. And in statutory terms, that's 20 years from the filing date, potentially, that you can have that monopoly. Now, it doesn't, there is a price to be paid for this, because in being granted this period of exclusivity, you have to exchange, you have to disclose your invention to the world. And so in your patent application, what you have to do is really explain to the world how your invention works, how it's put into practice, what's the problem that it addresses. So this is the sort of bargain that you have with the state. You're furthering the frontiers of science, pushing them back, and in return you get a limited period of exclusivity. A patent document. I don't know if you folks have seen what a patent actually looks like, but it's a set of instructions that describes an invention and how it works. So it'll typically have an abstract, a background, a summary of the invention, and a bunch of drawings that show how the invention is put into practice. And so at the end of this document are a set of claims. And from a patent agent's standpoint, it's the claims that are really the most important, because the claims define the scope of protection. So those are the sort of the stakes that or the fence in the field, if you like, that sort of cordons off what you consider to be yours and what you are preventing other people from doing. Now, so one thing to bear in mind is that, with this protection that you get with a patent, you don't automatically get government enforcement. So, you apply for a patent, you might get a patent at the end of the day, but you still have to actively police that patent. You have to be on the lookout for what your competitors are doing and see whether someone is moving onto your turf, as it were. Very quickly, I'm going to touch on ownership here. So much like for copyrights, the creator of the innovation, and I'm assuming it's an invention here, they are presumed to be the first owner of that invention. And so in the same case as before, whoever has been working on it and has reduced this invention to practice, they are presumed to be the owner, and unless there is an agreement to the contrary. So again, if you have an agreement in place that says all rights and all intellectual property that's developed, including any inventions that are created in the course of this process, belong to the company. Unless you have something like that, then potentially you're going to have a contractor who works on a solution to your business, but they would actually have the rights to that potential patent. There's a second sort of qualifier here. So in the situation where you've hired an inventor, you hired an employee to specifically work on your problem, maybe he's an engineer, or maybe he's a developer, and he's hired for that purpose. Anything that he creates in that situation can flow to the company. But in the absence of something like this, you have to be very careful that you have provisions in place to make sure that ownership in the invention and the patents that flow from it go to the actual company. So typically when you develop an innovation, this is the sort of general process. So you start off with the discovery or the innovation. For a period of time, you should maintain it as a trade secret. And so, until you know that you might go down the patent route, that it's very important to treat it as a trade secret anyway. And then at some point in the future, you're going to assess it for patentability. And so there I'll go into a bit more detail in terms of what that entails to determine whether your innovation qualifies for patent protection or not. And then if it does clear those hurdles, then you go through the process of applying for a patent. And then if you're successful, at the end of the day, you end up with a patent grant, which you can then exploit. You can then assign the rights to that patent exclusively outright to another party, or you might decide to license those rights, not exclusively or exclusively to other parties. And so, as I said, it's important to maintain secrecy for your innovation. This is the general rule. So if you have a disclosure of your invention without having filed an application for it, then generally speaking, you can lose the rights to obtain patent protection for that. And this applies for a number of countries in the world. The good thing is that in North America, Canada, and the US, there is a 1-year grace period, meaning you can disclose your invention to the public, but then you have 1 year within which to file a patent application. A lot of clients sort of lose sight of this, thinking, well, I'll be fine. In Canada, there's a 1-year grace period. They share their invention to, maybe it's a conference or with another party, not realizing that the clock has already stopped for them and that they may have lost the ability to apply for patent application in other countries. So that's something to sort of keep in mind. If there's a way to kind of deal with it in the meantime, because you have to disclose it to some other party, make sure that there's some sort of confidential sort of relationship there. So something like a non-disclosure agreement or some other confidentiality agreement with the party that you're disclosing that information to. Requirements for patentability. So there's 3 or 4 basic requirements. The first is your innovation novel? Simply put, it's just, has anyone else come up with the same solution or the idea already? Now that's usually quite easy to determine. But the second requirement is non-obviousness or inventiveness, as it's known in some places. So this is usually that's a stumbling block for most innovations. What it really means is, so is your invention or your improvement such a small improvement on what other people have already done and what is already known? So a bad example I kind of use for reference, if someone has come up with a 4-legged table and then let's say they patented that 4-legged table. If you come along and say, hey, we're great if I add 2 legs to it and make it a 6-legged table, that's very likely going to be obvious, because any engineer is going to know, well, if you take a 4-legged table, you add some more legs to it, make it more sturdy, that's not really an inventive or non-obvious improvement. The third requirement is utility. In essence, it just means, does your invention have a useful function? So assuming it achieves a useful function and it can actually deliver on that, then it usually will meet that utility requirement. It really is the non-obviousness that typically is the tricky question to answer. And then finally, subject matter. There are certain things that qualify for patent protection and also some exclusions. So when you sit down and assess your invention, you have to kind of determine whether it meets any of the subject matter requirements. So in general terms, this is the statutory language that says any art, process, machine, manufacture, or composition of matter can qualify as a patentable subject matter. And so I've listed some examples there of things that traditionally are considered appropriate subject matter. Things like mechanical devices and machines, drugs, maybe a chemical process or industrial manufacturing process. And then more recently, we include in that computer implemented invention. So basically software that's carried out on a computer. There is some scrutiny with inventions in that space. But generally speaking, depending on the purpose behind it and what function it achieves, it's a possibility to get patent protection for software-based or computer-implemented inventions as well. Business methods, those were all the rage not too long ago, but essentially, I think for most patent offices, I think the overall consensus there is that the business methods themselves probably don't qualify for patent protection. So some examples, other examples, things that can be patented, abstract ideas. And this is the, when we're talking about software, this is usually the question mark here. With software, very often what we're doing is we're playing with ones and zeros. It's just, you have data that's being modified in some way. And so the presumption with that is that it's abstract because you don't have any physical effect. You're not doing anything with that data. And so the presumption is that it might be considered abstract. And that's why I say, you have to look at that software to see what it does. And is there some sort of physical manifestation or some sort of technical effect that comes about? And if so, that may be enough to overcome that presumption. And then other things that you can't protect with patents, scientific principles, and like something like E equals MC squared, that's a discovery, but that's a principle that's kind of known in science, and so you can't actually patent that per se. And then things like mental processes and mathematical algorithms also fall into that class. So the overall patenting process, assuming you've sort of cleared all those hurdles and determined that you've got something which is worth patenting, the process looks like this. You have to prepare and file an application, first of all, that basically sets out what your invention is. And then at some point in the future, and you send that into the patent office. But at some time in the future, a patent examiner will pick that application up and conduct his own search to see whether your invention meets the four requirements that I mentioned earlier. If so, then you get a granted patent at the end of the day. More commonly, the examiner may come back and say, hey, well, your application is very similar to something else that I found. And he may cite other patent documents against your application. In that case, then we have the opportunity to kind of argue against that allegation, and in which case we can directly address the rejection, or we may also amend our application in some way so that we avoid whatever was cited against us by making sort of differences in terms of what we're claiming. When it comes to the first filing, just you may actually be able to help as the technical person, or maybe you're the founder. You can actually help that process along quite extensively by working closely with the agent to describe what the problem is. What are the ins and outs of your innovation, and how do we actually put that into practice? And so, the sort of the process of describing the invention, you can really do a lot of the heavy lifting there. And at the end of the day, the patent lawyer or agent can then focus on some of the more sort of critical aspects of, for example, claiming the invention, making sure it's properly protected. One thing to keep in mind with patents is that they are territorial, meaning if you apply for a US patent, that potentially will give you protection in the US, but it doesn't give you any protection elsewhere in other countries. And so when you have an invention which perhaps is not geographically limited, so let's say it's a piece of kind of like a software process, there's no reason why it has to be limited anyway. And so, for something like that, you have to think about protecting it in more than a handful of jurisdictions. And so the problem with that, of course, is that it becomes very expensive to do so. If you file 5 applications or 10 applications in different countries, that becomes difficult and also expensive. But there is a way to kind of offset that a little bit by taking advantage of patent treaties. And so the first is that there's something called a convention priority. So if you file an application somewhere in the world, that actually entitles you to file a subsequent application within 12 months. That can then that can piggyback off that first application. So by allowing for this, you can effectively kind of defer the costs. You're buying yourself an extra year before you have to take that step of filing that application in other countries. And then a lot of our clients actually make use of something called a US provisional application. So in the same way that you file a first application somewhere, you can file the first application as a US provisional application. A provisional application is sort of like a scaled down version of a regular patent application. It allows us to cut a few corners. And so we can put an application on file at fairly reduced cost and relatively quickly. And so that's something else we can make use of to kind of preserve our rights before we have to decide, do we have to now file in a number of countries to protect it more broadly. And then in the situation where you require broad protection for your invention, there is something called an international application that we can make use of. The PCT application, as it's called, once you file it, it's a single application, but it entitles you to reserve the right to convert it into a national application in any country of your choosing. Basically, I think there's about 150 countries that belong to the system. And so again, you're sort of buying yourself quite a bit of extra time before you have to kind of really spend a lot of money with the related filing costs. And so this is a very simple kind of illustration of what typically happens when you have an invention that you want to protect in many countries. You start off with first filing typically a US provisional application on the left there, and then within 12 months, you file the international application, which claims priority of the first filing. And then that buys you basically 2.5 years within which to decide, okay, now I need to, I've got a lot of commercial interest in this invention. Now it's worth spending the money to convert that into a European application, a Japanese application, and so on. So I've skipped through that very quickly, but I've also got some takeaways at the end of this, which literally I think you can take away if Angie makes it available. But I think we have a few minutes for questions.
Yes, thank you. So thank you, Ling. Thank you, Roger. I think Roger's still here. In case there's some questions.
Yeah, I'm still here.
Roger. Great. In case there's questions for you too, I'll add you in here to our Zoom spotlight. So it's a couple of minutes before 2, depending on Ling and Roger's meeting schedules, we might go over by a couple of minutes for questions.
Sorry.
But if you need to leave, thank you for joining us. And next week is business case and angel investment with Mike Volker. So please join us for that. So thanks for joining us. Otherwise, I'm just going to zip through some general questions. Does integration of different technologies, is that considered patentable?
Sorry?
Is the integration of different technologies considered patentable? Or if you're integrating two technologies, maybe two existing technologies?
Well, potentially you can be. There's this sort of point goes to the sort of the obviousness question that I mentioned. So if you are taking two unrelated concepts and putting them together, that may result in something which is patentable. But there's a risk that an examiner will say, well, your process is A plus B. A is already known, B is already known. And so the examiners in some cases will be entitled to combine A plus B because they're all both widely known, combine the two and say, well, that's essentially what you've done. It's obvious, right? The question becomes whether those two, whether A and B perhaps relate to different fields. And if they're completely unrelated, the argument would be that no one would think to combine those two things. But if they were in fairly related fields, then the argument would be, well, an engineer would kind of look around that particular field and then probably would encounter the other part of that, and so that would make the invention obvious.
Okay, great, thank you. Can a robot shape or design be trademarked?
Oh,
Oh, okay, go on. Roger.
you got me there for a minute because I thought robots, that must be patents. If it is the packaging of a good, and if the robot shape is intended to indicate where the robot, who made the robot, right? So it wouldn't protect the functionality of the robot. If someone sold a similar robot in a box and you couldn't see it when you bought it, then maybe it wouldn't be. But the Coca-Cola bottle, the shape of the bottle is a trademark. So yeah, very interesting.
Okay.
I don't know if the trademark can be the product sold, but yeah, if the shape of the product can be the trademark, maybe.
Okay, so we're worth looking into further.
You stumped me.
Yeah, a couple more on trademarks. Do you have to register the trademark, or is use enough? And is it worth going for any formal protection in China?
So question number A, it's very important to register trademarks. Unlike copyrights, the rights that you get through common law are pretty bad. They are limited to the geographic area where you're using the mark. If you register a mark in a country, then it's, you can cover the whole country. So that's important. And there are other reasons why you've got more, you have a number of sections under the Trademark Act that you could rely upon when you take action against another party. Absent registration, relying on common law rights, you'd have to have an action in passing off the burden of proof. It's more complicated to get a result from that type of litigation. So registration is important. China, yes, do it before you even use the trademark. You'll recall that when domain names became important, there were cyber squatters, and there were people, actually someone locally, who made tens of millions of dollars by registering the domain names for well-known brands. Well, in China right now, they're registering trademarks. So let's say you come up with a new product, you apply to register in Canada and the US. They see that on the internet. Maybe they see you filed an application to register in China, in Canada. Then they go ahead and file one in China, and they wait for you because they can. We had an instance where one of our clients was interested in trademarking in China. We went to an agent in China. We said, here's the mark, how much you think it's going to cost. Okay, went back to the client like a week later, said, okay, go ahead, file the application. In that week, someone had done it. I don't know if it was that our agent that we were working with was unethical, or if, there's just people checking in on emails or whatever, but it's like the Wild West. It's real crap, I tell you. And we're dealing with some companies that you would know from our local emerging company scene, and some that are somewhat established. And we're dealing with issues where they just cannot get their mark in China, and other people have kind of gone in and scooped it.
Okay, a couple more quick ones here. Here's kind of a good general question, which is, why is patenting so expensive? And are there any ways to make this process less expensive?
Yeah, I agree. Patents generally are fairly expensive, but that, the main initial cost for that really is the sort of the legal time that's required to fully describe the invention that you've come up with. And so, as I mentioned, there may be ways to kind of reduce some of the costs, and this requires the technical team to kind of work closely with the patent agent. When it comes to something like the background to an invention and what the problem is, they probably already know that, or they probably have already done that work in coming up with presentations and things like that themselves. So they can kind of very often repurpose some of that information to use as kind of the preparatory material. And then the patent agent doesn't have to quite sort of draft from scratch. So that's one thing. And then the other thing is the sort of the different treaties that are available. I mean, it doesn't make it cheap, but then it can certainly defer some of the costs that would otherwise be incurred.
And out if anyone missed Eric Koss's note there, Eric's an NRC IREP advisor. There is an IP assist program for their clients, up to $30,000 in funding to help firms learn about IP. So Google that one. Eric will actually be here speaking in a few weeks, so you can ask him more then too. Okay, it's 2:05, so I'm mindful of time. I know we didn't answer everyone's questions, but Ling and Roger, is your contact info on your PowerPoint? It is.
Yes, it should be.
Okay, so Fasken has been New Venture's sponsor basically since the beginning and have worked with tons of startups and have always been very generous with answering questions and following up. So please do get in touch. And I know they look like I mean, they are a big fancy firm, but they work with a lot of startups and you know, always hear great testimonials from companies coming forward. So definitely reach out if you have any further questions. So yeah, we're going to wrap it there just to be mindful of time. But Roger and Ling, thank you for yours and for all the information. And I'm sure we'll see you again next year, I hope.
You're welcome. Good luck, everyone.
Yeah, good luck, everyone.
Okay, thanks everyone. Thanks for joining.
Thanks.
Bye, take care.